Hi everyone, welcome back to CLAT Possible YouTube channel. Today we are going to discuss a very important concept of criminal law, that is the last seen theory in criminal jurisprudence. This theory is used for conviction in criminal law, for declaring somebody guilty for having committed a criminal act under the law. And what is the relevance of this theory, how this theory works, what are the key concepts around this theory, and how the courts have evolved and interpreted this theory. All of that we are going to discuss, and even how this theory is relevant in the latest ongoing Meghalaya murder case. All right, so watch this video till the end to get the best out of it. Last scene theory we are going to discuss. This is a recent case that has happened, and the Supreme Court has said in this case that last seen theory in itself cannot be the basis, cannot be the sole basis of conviction, especially when the time gap is not uh, conclusive, it's not clear. Anyway, we'll come to that later. First of all, what are the facts? So you can see that the accused was last seen with the deceased near a river in a cashew field, and the deceased's body was found floating in the river the next day. So there is a firstly, what is happening? There was a last seen accused in the sense the one who is facing a criminal trial, okay, against whom there is a criminal accusation. He was last seen with the deceased, and then the body was found next day. So last seen का मतलब ये होता है लॉ के अंदर कि let us say that somebody is found dead. Now the police must be investigating, the courts must be inquiring. So who seems to be the suspect in that case? Who seems to be the prime suspect? The law says that as per the last seen theory, the person with whom the deceased was seen or found right before he was found dead. Okay, the person with whom he was found before he was found dead, or he was found alive before he was found dead, is the last seen theory concept, and that person will become the prime suspect in that case. And in a lot of cases, it has happened that the one who was lastly seen with the deceased was found to be the real culprit, and that's why this theory has a significance in the criminal jurisprudence. तो ये फैक्ट्स हुए थे लास्ट सीन के और कोर्ट ने इसमें क्या कहा है वी कैन सी द कोर्ट हैज क्लियरली सेड दैट the court acquitted the accused due to lack of corroborative evidence. Lack of corroborative evidence. तो ये हम पढ़ने वाले हैं कि corroborative evidence क्या होता है और उसकी कमी की वजह से due to lack of it the court had to acquit. Acquit का मतलब होता है to set somebody free, to discharge somebody of guilt. That is to declare not guilty. It's called acquittal. ठीक है? This is not guilty. And corroborative evidence का मतलब होता है supporting evidence. Supporting evidence. तो अभी इसको हम देखेंगे what is supporting evidence, but कोर्ट ने इस केस में उसको एक्विट कर दिया और कोर्ट ने बोला कि the time gap between the last sighting, that is the last scene, and death was unclear, and hence no exclusive opportunity was shown to link the accused with the crime. This is very important. The court said that the time gap was unclear in the sense when was the accused lastly seen with the deceased and when the body was really found. So there is the time gap between the two acts is not clear, and therefore we cannot apply the last seen theory directly, and we cannot convict the accused merely based on the last seen theory. So one understanding that we can have from here is that if there is too much time that has passed between the last scene, between when the accused was lastly seen and when the deceased was found dead. If much time has passed, then it will be very difficult for the courts to apply this concept and convict the accused. This is what we understand primarily from this. Now let's look at this concept even further. What are the key takeaways? The last seen together theory alone is not enough to sustain a conviction. So this is very important. He, if just because, merely because the accused was lastly seen with the deceased before the death is not enough, is not sufficient, will not be an isolated ground to hold the accused liable and to hold the accused convicted. Okay. Uh, That means we need something else. There has to be something else along with lastly seen. Now that's what it is. Corroborative evidence is necessary to establish the accused guilt beyond reasonable doubt. What is corroborative evidence? I just told you. Any evidence which is in support of another evidence. A piece of evidence that supports an existing presumption is called corroborative evidence, right? So let's say the presumption is that since the accused was lastly seen with the deceased before his death, accused becomes the prime suspect. And but that's not enough in itself. So what can be the supporting evidences to this presumption? What can be the surrounding and supporting evidences? So for instance, if there is a CCTV footage that confirms that yes, he was lastly seen, and after that the deceased met nobody else, there was no interference by anybody in the deceased's life, that particular time moment or that particular day becomes a crucial corroborative evidence. Even evidences like when the police found weapons, if the police have recovered weapons or have found other evidences that link the connection of the accused to the death, to the killing, then it will be called supporting evidence or corroborative evidence. Okay? So, in the absence of corroborative evidence, which is extra evidence, you can say additional और supporting evidences अगर नहीं है तो ये थ्योरी अपने आप में काम नहीं आएगी. एंड प्रूफ बियॉन्ड रीजनेबल डाउट का मतलब क्या होता है कि the court must be convinced with a certain story, with a certain theory. Now let's talk about the Meghalaya case. What has happened in the Meghalaya murder case is that there are evidences that the deceased, that is Raja Raghuvanshi, was found dead. And before he was found dead, he was lastly seen with a few persons. 3 to 4 persons were there. This is based on the evidence and witnesses that have come so far. The shopkeepers and the fellow tourists, uh, fellow people present there have all narrated that they last saw the deceased with 3 to 4 people, and that's what last seen theory says. Now, my question is that just because he was seen lastly with a certain number of people, does it conclusively determine the guilt that those are the ones who actually killed him? So the court answered in this case that it will depend on the time gap. अगर बहुत ज़्यादा time निकल चुका है तो फिर इस थ्योरी पर यकीन करना मुश्किल हो जाएगा, और अगर कम टाइम पास हुआ है तो फिर still this theory is believable. So what happens in that case is subject to investigation which is currently going on. But in my opinion, the not enough time had passed. Not enough time had passed between when he was seen with a couple of people and when he was found dead. So I think last seen theory can be validly applied on this case. Okay, but understand one thing, that last seen theory is not applied at the police stage. It is applied at the conviction stage, which happens in the court. As of now, that Meghalaya murder case is pending with the police. When it goes to the court, then we will see, when there is a trial, we will see that this concept will be utilized. And I think it can be validly applied in this case. Now, suspicion. Suspicion is a mere presumption, or you can say having an idea or having a doubt against somebody's involvement in a crime. But suspicion may be very strong, but it cannot replace the proof beyond reasonable doubt. See, there is a difference between suspicion and proof. Suspicion is merely a presumption, merely an idea or a doubt. Okay, and based on suspicion, you conduct investigation, carry out inquiry, etc., and reach to a formal conclusion. But suspicion is not proof. Proof is dependent on evidence, on clear evidence. Now, that evidence may be direct evidence or indirect evidence, primary evidence or circumstantial evidence, whatever the case may be, but there has to be evidence for proof. For suspicion, you don't need proof, right? In fact, suspicion is a part of proof, but not the only thing to conclusively prove. Anyway, so beyond reasonable doubt, का मतलब क्या होता है? The court must be fully convinced that this is the only story which is possible in this criminal case, and there is no alternative to this story. If that is the understanding of the court, it becomes beyond reasonable doubt. मतलब उसमें कोई स्कोप नहीं रहना चाहिए. The story that has convinced a judge should not have a scope of any doubt, in the sense it should sound logical, real, and sensible, and something which has actually happened. This is what it has to sound like. Anyway, we just come to that in a while. And before that, we just understood that life last seen together in itself is a weak piece of evidence, and it requires corroboration. That means support. Needs support, needs more evidences which are linking the accused to the crime. Okay, this is what the court has held. Now, what are the key legal concepts surrounding this concept? First is circumstantial evidence. I just talked about this. Evidence that proves a fact by implying its existence. Implication based on presumption. Based on presumption, it is called. See, I'll tell you there are two kinds of evidences. First is direct evidence, and the one is the circumstantial evidence. Matlab, evidence based on circumstances that what might have happened. So there is a lot of guesswork in this. There is a lot of presumption involved in this, but that presumption is quite sound and logical. So I'll give you two examples to understand this concept. Let's say A kills B, and this act of killing was noticed by C. Let us say C was present and he saw that. This is the direct evidence. If C goes to the court and says, I have seen A killing B, this is the direct evidence. It is not circumstantial. Okay. And this can be sufficient in itself. But let us say C says that I did not see A killing B. I have not seen that act in itself, but I saw A and B together at 9 p.m. Okay. And it is found that in the night at 2 a.m., B was found dead. Now, this becomes a circumstantial evidence because C has not directly seen the act of killing, but there is a circumstance, there is a condition, there is a situation of such a nature which leads us to presumption that most probably, A has killed. So that most likely scenario, the most probable scenario is called the circumstantial evidence, and it has a value in the law, but it is a weak piece in itself. लास्ट सीन के बेसिस पर अपने आप बिना किसी corroboration के punishment नहीं हो सकता. So last scene is a good concept but needs support. If there is support, then yes, there can be conviction. This is what the court has said. Although there are a lot of judgments of the Supreme Court where the court has said that okay, last scene can be enough if not much time has passed. Let us say if the accused and the deceased were found together at 8:30 p.m. and at 9 p.m. or 9:30 p.m. the deceased was found dead, there is not much time which has passed. So in that case, the courts have said that last scene alone would be enough. Okay, but we will not get into that. We will only look at what is the present concept here. That needs corroboration. What is corroborative evidence? I already explained. That supports or confirms other evidence, supporting or confirming other evidence, right? So, see the police. Let us say that lastly scene has happened. Okay, now the police have to carry out investigation. They cannot stop investigation merely on that basis that now we have come to the conclusion. Investigation करना पड़ेगा, right? And during investigation, if they find more evidences which are linking the accused to the death or are supporting the existing circumstantial evidence of last scene, then yes, there can be a greater suspicion which can convert into a proof beyond reasonable doubt, and there can be conviction based on that. ठीक है, तो ये आपको देखना पड़ेगा कि confirmation हो रहा है या नहीं हो रहा है. Proof beyond reasonable doubt is the same thing I just told you, that there should be no scope of doubt left in the story given to the judge, presented to the judge. If there is any doubt that this may not have happened. Okay, I'll give you another example. Let us say there are two persons in a room. Okay, and they were lastly seen at 8:30 p.m. right, entering the room, and it so happened that one of them was found dead in the morning. One of them was found dead in the morning, and there is a clear evidence that nobody went inside Okay, and nobody came outside. It's very clear. But nobody has seen what exactly happened, whether A killed B or not. It's not clear. But what is clear is that they were in a room and nobody came inside, nobody went outside. Now, the point is that if the person, one of them is found dead, the prime suspect will be the other person who was there with the deceased, right? And now you see that if the post-mortem report confirms that it is not a case of suicide, if it is not a case of suicide, then naturally, if that person has been killed, which is clear, either it is suicide or murder, if there is a murder, who must have caused it? Who must have committed it? The other person who was there with the deceased in the room at that moment. But nobody has seen him committing the crime. But you see, the presumption is so strong. The presumption is so strong that it will convert into a proof beyond reasonable doubt because there is no scope left. Nobody came inside, nobody went outside. Then who must have committed the murder? Right? Are you getting the point? So this is sometimes called circumstantial evidence, and on that basis, yes, there can be a proof. On the other side, there is also presumption of innocence. Normally, जब तक कि किसी को guilty prove नहीं किया जाएगा, तब तक उसको innocent माना जाता है. Innocent until proven guilty. But once somebody has been proven to be guilty, then obviously the presumption ends there. It is only a presumption, which means a belief. Simply refers to a belief. Only a belief which is subject to proof and contradictions. Benefit of doubt क्या होता है? Like I said, if we have proved the case beyond reasonable doubt, तो वो conviction हो जाएगा, वहां पे उसको valid proof माना जाता है. But it is also possible that let us say if there is no, the case has not been proved beyond reasonable doubt. इसका मतलब क्या है कि there is some doubt left in that story. अभी कुछ गड़बड़ है उस स्टोरी के अंदर, ठीक है? तो ऐसा हो सकता है कि द केस दैट आई डिस्कस विद यू, लेट्स से nobody saw anybody entering the house or leaving the house, but the door of the house was open in the morning. The door of the house was found open in the morning. Now you see there is a doubt created. What is the doubt created? That probably somebody had entered the house and left it. Although nobody has seen them, nobody has seen it happen, but the door is open. It's not closed, especially when it is not closed from inside. Okay, now if it creates a scope of doubt. So जहां पे doubt होता है, वहां पे जो accuse होता है, उसको मिलता है benefit of doubt. In the sense कि उसको benefit of doubt के basis पर acquittal मिल जाता है. Accused is entitled to the benefit of doubt, which leads to acquittal. So the other person who was there in the room with that deceased will get a benefit of doubt, क्योंकि now there are multiple possibilities in that story. It's not just one way story. Okay. Suspicion versus proof already explained. Suspicion is maybe a way towards the proof, but is not a proof in itself. Okay. So I think this should not be confusing anymore. Motive is the motivation to commit a crime. Sometimes people have motivation, and almost all the time, in fact, people have some sort of motivation to commit a crime. If a thief is stealing an object because he needs money, he's poor, so poverty would be the motivation. To handle the poverty would be the motivation. Okay, if a man kills another for taking revenge, then revenge is the motivation. So what motivates one to commit a crime is called the motive behind the crime. Chain of circumstances already explained, the complete chain of circumstances that leads to the conclusion that accused committed the crime. So the example that I just gave you, that two persons found in room, one was dead, nobody entered, nobody left, the door was closed from inside. All circumstances lead to the presumption that the other person in the room had actually committed the murder. Corroborative evidence is essential to sustain a conviction. Already explained, कोर्ट ने बोला है कि सपोर्टिंग एविडेंस साथ में चाहिए, और क्या होता है वो मैं आपको ऑलरेडी बता चुका हूँ. But there are other court judgments also which have said that if the time gap is not much, then we can rely solely on the last seen theory, and if all other evidences match, yes, we can rely on that. This already I have explained that the accused is presumed innocent until proven guilty, and अगर beyond reasonable doubt कोई crime prove नहीं होता है, if there is any scope left of doubt, तो फिर उसका consequence ये होता है कि वहां पर एक्विटल करना होता है कोर्ट को, मतलब उसको बरी करना होता है, डिस्चार्ज करना होता है, एंड दिस लीड्स टू अल्टीमेटली not declaration of not guilty for accused. Right. So this was the crux of the judgment. The Supreme Court. This was the case, and it has highlighted the importance of corroborative evidence, like I said, because it needs to be there, especially when time gap is not clear. Let's understand the law in its essence. It's not saying that for that last scene in no case will be the conclusive evidence. It is not saying that. It is only saying that if the time gap is not clear, especially in that case, we cannot rely only on last scene. We have to have more evidences, right? So understand the judgment in its true essence, and every judgment comes with a different interpretation, might come with a different interpretation, but you have to focus on what is given to you in the passage. All right. When you will get a passage on this, focus on the language of the passage. Do not, be under a preconceived impression that no, in this case it had happened, so this is the universal rule. It's not like that. Your passage can give you something else related to this. Okay, and that's what you have to learn. I think all of this we have already understood that there has to be credible and reliable evidences which are supporting the circumstantial evidence. So now, why this topic is important? Because in CLAT you expect passages from current legal affairs, and there is a difference between passages getting in GK based on current affairs and passages in legal based on current affairs. Is that GK normally has passages which are of national importance and are like crucial facts for you to know, but in legal passages which are picked up from current legal affairs are not necessarily the topics of high public interest, but the ones which contain deep legal reasoning or legal points. Okay, if there are certain legal contradictions or legal points involved or laws which are capable of multiple interpretations, तो इस तरह के जो passages हैं वो आपको ज्यादा वहां से pick करे जाते हैं from legal current affairs, and that's why this concept becomes important for you, because I told you there are different interpretations on this concept, and it is currently it was in the news also, right? So keep reading more legal current affairs, keep understanding the law in them, and try to think from like a lawyers and apply that reasoning to the questions. You can also create your own questions in your mind. You can imagine the questions and you can imagine the situations and try solving that based on the law, right? But do that. Legal current affairs is very important for all of you, and you need to have diverse kind of reading, diverse kind of reading. So do subscribe this channel if you have not done it already, and we will keep coming up with more diverse legal areas, with more diverse topics of law, so that you stay fully prepared for CLAT, uh, especially for the legal section. So thank you so much and take care. All the best.